When no means no, a lesson on government promises and final judgments. Have you ever been offered a solution to a problem, rejected it because you wanted something better, and then ended up with nothing? That is exactly what the High Court had to decide in the case of a retired army colonel against the state. Here is the story of the Kitwe House, the Kafiwe land, and the law of finality. The story begins in the 1990s. Colonel Chukuswe, a civil officer, was living in a government house in Kitwe. When the government introduced a scheme to sell these houses to sitting tenants, the colonel applied, paid, and even received a title deed. However, there was a major dispute. Another officer, Lieutenant Colonel Sianga, claimed he was the rightful sitting tenant. This turned into a long legal battle that went all the way to the Supreme Court. The result, the Supreme Court ruled against Colonel Chukuswe. They determined he was not the lawful tenant and his title deed was cancelled. Years later, Colonel Chukuswe returned to the High Court. He felt that because he lost the Kitwe house, the government owed him compensation. He sued the Attorney General, asking for a refund of the money he paid for the Kitwe house, damages for a different house in Lusaka he was offered but didn't take, a declaration that he was entitled to prime land in Lusaka. The facts showed that the government had tried to help him. They offered him a house in Olympia Park, which he rejected, and later they offered him land in Kafiwe. The colonel rejected the Kafiwe land, insisting he had a contract for prime land in Lusaka instead. The judge dismissed the colonel's claims. Here is how she explained the law in simple terms. Number 1. Res judicata. Case closed true. The colonel built his new case on the argument that he was entitled to the Kitwe house. The judge reminded him that the Supreme Court had already decided he wasn't entitled to that house. Once the highest court speaks, the matter is closed. Res judicata. You cannot sue for damages based on a right you never had. Number 2. Contract law. The handshake rule. The colonel argued that because government officials discussed giving him land in Lusaka, a binding contract existed. A discussion or a recommendation by an official is not a contract. For a contract to be binding, there must be a clear offer, acceptance, and an intention to be legally bound. A government official trying to help you out of kindness does not create a legally binding business deal. Number 3. Ex gratia, the goodwill rule. The court found that when the government offered him land in Kafiwe, they were doing it ex gratia. This means out of kindness or goodwill. They weren't legally forced to do it. When someone offers you a gift to be nice, you cannot sue them because you didn't like the gift. Number 4. Doctrine of estoppel. You can't change your story. The colonel wanted damages for loss of opportunity regarding the house in Lusaka. The evidence showed the government offered him the house in Olympia Park, but he rejected it. Later, they offered land in Kafiwe, and he rejected that too. The law says you cannot reject a valid offer and then sue for damages caused by your own rejection. The court called his loss self-inflicted and voluntary. Because the colonel rejected the government's goodwill offers and tried to re-argue a case settled by the Supreme Court, the judge dismissed the case entirely. The colonel was ordered to pay the legal costs for the state. Lessons for us from this case. When the highest court makes a ruling, that is the end of the road. If you are in a dispute and are offered a reasonable alternative, think twice before saying no. Don't confuse a government official's recommendation with a binding contract. For more breakdowns of real court cases and the lessons we can learn from them, make sure to follow Legal Stories.